We've been looking at the rights and obligations that arise in business around carelessness. Specifically, we've been looking at the tort of negligence. And in the last series, we looked at what negligence is and when we owe a duty of care. In this series, we move on from that first element to the completion of working out whether someone has been negligent or not. That means we need to ask the questions, do we owe a duty of care from last week? Did we breach the duty, and did that breach cause the harm? We're also going to give an introduction to some of the defences that are available to a defendant if negligence is established. So we're moving on from what is negligence and when do we owe a duty of care, which is actually a bit of a difficult concept to get our head around when we first introduced it, to go a little more rapidly through the other two elements of breaching the duty and causation and the defences that are available as well. As a reminder, being negligent at law is different to being careless. To be negligent, you have to first owe a duty of care. You then must not live up to that duty of care, that you breach the duty of care, and then your carelessness must actually cause the harm that's suffered by the plaintiff. It's only when all of those three things have been shown that you're negligent. After you've shown that the defendant is negligent, you then look at what the plaintiff did, what the person who was injured did, because they might have done some things that made it worse, or in some cases they might have even fully appreciated the risk and taken it anyway. But we don't worry about that. We don't worry about what the injured person did, the plaintiff, until we establish negligence. That's when it becomes an issue. And we'll get to that later in this series. So if we've established that we owe a duty of care, we need to think about what it means to breach that duty of care. One way to think about this is to run a thought experiment in the extreme. So imagine you're driving a car and you just pull up quite normally to a set of red lights, and you're sitting there at a red light, and then someone just runs into you from behind. Now, it's very clear that you owe a duty to the person who ran into you. That can seem counterintuitive to a lot of people, but it's very simple. A motorist owes a duty of care to other road users, an established category that we covered in the last module. It just means that if you're a driver, you need to be careful, because if you're not careful, you could actually hurt or harm people who are on the road if you're careless. So you've got to take a bit of care. Now, just because you owe a duty of care doesn't mean that you've breached it. You may owe a duty and you may have been careful enough, or you may have not been careless. And so in this example, where if you just pull up normally to a red light and sit there and get hit by someone else, if they're the facts as we know it, there's nothing else you could have done. You have been careful. You haven't been careless. And so while you owe a duty of care to the person who hit you, you haven't breached that duty of care. And that's what we're looking at. We're looking at, have you done enough in order to be considered careful at law, considering you have this duty or requirement to be careful. Now, owing a duty of care is established at common law. That means the source of law are cases, either established cases or the tests for reasonable foreseeability and salient features of the case, or negligent misstatement, direct and indirect. In contrast, the test for breach of a duty is now contained in Section 9 of the Civil Liability Act. And here we have it here. Let's have a look. So this is an actual extract that I took from the internet that shows it, and I'm just repeating it here for clarity over on the left, using the exact words. So, person does not breach a duty unless the risk was foreseeable. And what does foreseeability mean? That it's a risk which the person knew or reasonably to have known. Again, we've got this reasonable person test. Is what happened the kind of thing that a reasonable person should have known about? Should they have thought about this kind of risk? Second, the risk was not insignificant. We'll come back to those words. So it's got to be foreseeable, not insignificant. And in the circumstances, a reasonable person, in the position of the person, would have taken the precautions. So we've got to work out What precautions should we have taken or could we have taken, and would a reasonable person have taken them? Let's think about this logically. If a risk is foreseeable, not insignificant, and a reasonable person would have taken some other precautions, then you've breached your duty. If any of these are not present, if the risk isn't foreseeable, if the risk is insignificant, or if a reasonable person would not have taken precautions, then you haven't breached your duty of care. So that means we really need to understand what these three elements actually mean when we go to apply them. So the first issue is that a risk needs to be foreseeable. If it's not foreseeable, then there's no breach of duty. And notice we don't see the word reasonable here. We're changing the test that we used for reasonable foreseeability about owing a duty of care. Notice we're asking, is the actual risk, the actual act of carelessness, omission or commission might cause harm? The defendant knew or ought to have known of that risk. That's a different test to, is it reasonably foreseeable that someone in this position could cause harm to someone in the other position? Test for owing a duty of care. You'll remember in that test we asked, is it reasonably foreseeable that if someone in the defendant's position is careless, they could cause harm to someone in the plaintiff's position? It was about a relationship and had nothing to do with the actual risk itself. If this person was careless, could they harm this person? Now this test changes. Was the actual risk that came to fruition foreseeable or not? If it wasn't, then you haven't breached your duty. If it was, then you have. And we really need to note again, this is an objective test, what a reasonable person in the defendant's position would have thought, not what the defendant themselves actually thought. Okay, if the risk is foreseeable, we've also got to make sure that it's not insignificant. Now, notice, not insignificant does not mean significant. They're two different things. Think about it this way. What to you is a significant amount of money? You might say, $100,000. That's a significant amount of money. And you might say, what's an insignificant amount of money? And an insignificant amount of money might be, $1. Okay, that's insignificant and that's significant. But then there's a whole range of money, and depending upon your circumstances between these. So for instance, is $10,000 a significant amount of money? I think for most people it is. What about $1,000? For some people, $1,000 is not life-changing, like it's not a significant amount of money. But it's also not an insignificant amount of money. Does that make sense? So there's definitely an amount of money that's significant, and there's definitely an amount of money that's insignificant. But in between, there's also this other area where it's not insignificant but not significant. So with this test here is about all of this area. Any risk that is not insignificant. So the way to think about this is you've got to think about what is an insignificant risk, and if the risk is not contained in there, then you've met the condition under 1B. If it's an insignificant risk, then you can't breach your duty. And we can see this in Thistle Company and Vernon, our case here. It all had to do with tripping on a plinth or one of those median strips in a petrol station. And the way it was painted, it was repainted black so it was harder to see rather than yellow. And so you can see here that the defendant is trying to argue that the risk of tripping on that median strip in the petrol station was insignificant. They're trying to get out of 9(1)B by saying it's insignificant. But the trial judge said that there was evidence that other people had stumbled or tripped on the plinth. And while there were no other incident reports, that meant no one felt that they had to report these stumbles or trips, which made it less likely that they actually caused any injury, that did not mean that the risk of tripping was insignificant. The plinth was a clear tripping hazard. It was not an insignificant risk. So you can see here that the only way you can apply this section to get out of breaching your duty is you must show that the risk is insignificant, either via being rare or that it won't actually cause any major harm. So if we can foresee the risk, and that risk is not insignificant, then we come to the third and final question under 9(1)(c). Would a reasonable person have taken precautions? Section 9(2) gives us the factors that we need to consider to work out whether a reasonable person would have taken precautions. Now, the way this is stated is it sounds like, does anyone take any precautions at all? But that's not really the test, because often companies and people will take some precautions. So for instance, if you think some steps are a tripping hazard, you might put in some non-slip strips and you might put in a banister that you can hold on to, right? So they are steps that you've taken. If someone trips, then the question isn't, did you take those steps? The question is, should you have done anything more? For instance, was the lighting good enough? Were they painted of a certain colour or with a non-slip paint that would have reduced it? Should you have done more than what you did, given that an incident occurred? So that's what this is really about. What other precautions could or should you have taken? Would a reasonable person have taken more precautions than what the defendant actually did? And to do that, we look at 4 factors. Now, you'll notice that this test is not an and or an or test. The point of the matter is that you have to consider the balance across all of these 4 factors as a whole, right? So if I draw some scales, you're trying to balance these things. And what is it that you're trying to balance? You're trying to balance the probability that harm would occur. So as the probability goes up, the chance that a reasonable person would take precautions goes up. The seriousness of the harm. Are you going to stub your toe or are you going to break your arm, right? As the seriousness of the harm goes up, or the likely seriousness of the harm, as it goes up, the more a reasonable person would take precautions. What about the burden of taking precautions? How much is it going to cost? How much inconvenience is caused? What are some other consequences? What is the overarching burden of doing more? The lower the burden of taking more precautions, the more likely a reasonable person would have taken those precautions. Okay? And then finally, the courts look at something we're not going to spend a lot of time in this unit, but the social utility of the activity. So is there some benefit to society in doing the activity that the risk led to? This is often used for cases involving emergency services, etc., because we want to encourage that kind of behaviour, the stuff that's good for society. So the courts cut them a bit more slack. Emergency services, sport often gets a bit of a slack because there's volunteers doing things that is good for society. Sport builds community, etc. But given we're doing business law, we're mainly going to be considering these 3. We've got to weigh the probability of the harm, the seriousness of the harm, and the cost of taking precautions, the burden. And realistically, the lower the burden, the more likely you should take precautions. Hopefully the idea of probability is fairly clear, right? The more likely something is to occur, the more likely a reasonable person would take precautions. But what about the seriousness? I think Paris and Stepney Borough Council is a great case for that. You actually had an employee who was blind in one eye, so they actually had one eye that was functional, and that person had a reputation for not wearing safety gear and not following instructions, etc. And so the employer got a bit annoyed with them and had given up on trying to get them to follow the safety requirements. And in the end, they were working in a garage and a bit of metal flew off and it actually hit them in their only functional eye. So they ended up going blind. And they were trying to say, oh, this person wouldn't do it, and etc. And we took some precautions. We tried to take precautions, but they wouldn't follow instructions. But the court held that because this person only had one eye, they needed to take more precautions than if someone had 2 eyes. Now, hopefully that makes sense, right? Because the seriousness of losing your one good eye is far higher than the seriousness of losing one of 2 eyes. Going totally blind is much more serious than losing one eye. And therefore, a reasonable person would take more precautions. There was a higher requirement in this situation. So the seriousness affects the expectation. In terms of burden, this is the one that companies really have to think about. Like, how much policy and procedure do you actually put in place around risks that might be there? And I think the easiest way to think about it is if you can take some relatively simple precautions that don't cost a lot, then you should. Because if you don't take them, then you're liable to be a breach, because a reasonable person would take relatively simple precautions. Now, this is a very difficult area to give a solid answer to, right? Because I think we have clear cases of where you do and where you don't need to take any more precautions, and then a whole lot of grey area between them. Let me give you an example. Just say someone spills some olive oil in a supermarket. Now, clearly, the shop should clean up the olive oil spill. The probability that someone's going to slip on an olive oil spill is pretty high. If you slip, you can have serious harm, etc. The burden, cleaning it up, it doesn't take a lot to clean up the spill, so you should do it. So it's not the cleaning up that really is in question, but there becomes a question of how quickly should you clean up, right? Now, if you left it there for 2 weeks, that's obviously too long, right? And you could have cleaned it up relatively easily beyond that. Even a day is too long. And then we just start cutting it down. What about 1 hour? 1 hour is probably too long. Okay, what about 5 seconds? Should you have to clean up a spill within 5 seconds? Well, you probably wouldn't know about it. You'd have to have someone standing at the end of each aisle, and that's crazy. That burden is too high. Well, is it 10 seconds? Is it 15 seconds? Is it 2 minutes? Is it 5 minutes? Can you start to see the problem? That there is clearly an area where the burden is too high, where you don't need to clean it up within 30 seconds. And there's clearly an area where it can be too long. Waiting an hour is too long for spilled soil. But then in this, there's a whole lot of greyness about the burden that we should take. And they're the kinds of issues that cause businesses problems, thinking through those things in policy and procedure. What we do know is that there are limits, and for instance, the Road Traffic Authority of New South Wales and Dedera is a great example. It was where an unfortunate young gentleman jumped off a bridge and actually injured their spine. And on the bridge there were these no diving signs, and there was evidence that they'd actually tried to get the police to stop people diving, but people kept diving. And the question was, should the owner of the bridge, the Road and Traffic Authority of New South Wales, were they negligent in not doing more to stop the jumping off the bridge? Should they have put up huge fences or nets or done something else to stop them? And what the court held was that on balance, no, they'd done enough. And what was the court saying? In this particular instance, they need to weigh the value that the risk was low, and they knew that the risk was low because people had jumped for a long time and no one had ever been injured. So realistically, the risk was quite low. Second, people have to take responsibility for ignoring signs. If you're going to ignore a don't jump sign, a little bit of it is on you. The third thing that the court looked at was the fact that it would have cost a lot to do any more. The burden was very high to build fences over every bridge where people jump off or have nets, etc. That's a big burden. And so on balance, in this situation, they said, no, the Road and Traffic Authority had not breached its duty of care in this particular instance. So there are limits to how much care you need to take. And then finally, the one that we're not going to do a lot of time on is social utility. If you're doing something that's socially useful, you're less likely to have breached your duty of care. You get cut a little bit more slack from the courts. And so there you have it. That's how you work out if someone has actually breached their duty of care. Have they done or not done something that they should have done, given that they owed a duty? And we look at whether the risk was foreseeable, that risk was not insignificant, and whether a reasonable person would have taken precautions under Section 9(1) of the Civil Liability Act. Remembering, of course, that we work out whether a reasonable person would have taken precautions according to the 4 factors set out in Section 9(2). And with breach established, you move on to the final requirement for negligence, causation, in our next video.